Article 1, Section 10 by Richard E. Epstein and Jack Rokoff. Article 1, Section 10 contains a long, somewhat diverse list of prohibitions on the power of the states to engage in certain activities. Understanding its significance depends on first placing it within the larger framework of Article 1, which is primarily devoted to setting out the structure for Congress and then enumerating its legislative powers. Those activities occupy Section 1 through 8. Section 9 prohibits a broad array of activities by the federal government which run the gamut from weakening the privilege of the rate of habeas corpus to taxing exports from the states. Section 10 imposes a similar list of prohibitions on the powers of the states. Clause 1 contains absolute prohibitions that Congress cannot waive. Clause 2 and 3 impose prohibitions that Congress can waive, presumably by legislation, although the text does not make clear whether any joint resolution is subject to a presidential veto. It's difficult to explain why the prohibitions found in Clause 1 cannot be waived by Congress while those in the last two clauses can be. But in both cases, the state interests are made subordinate to those of the national government. These prohibitions in Section 10 can be divided into several subclasses. One group imposes on the states some of the restrictions, and Section 9 imposes on Congress the power to pass bills of tenure or ex post facto laws or to grant titles of nobility. The second category guarantees that matters of war and diplomacy belong primarily or exclusively to the national government. States are prohibited from forming compact with the foreign nations or even with each other without the assent of Congress. The third category applies to financial matters dealing with such issues as the power to coin money, emit bills of credit, or lay duties on imports and exports. During the Revolutionary War, both the Continental Congress and the states resorted to the massive insurance of various instruments of credit, unsecured by adequate taxation, resulting depreciation in the value of those instruments, coupled with the corresponding inflation of prices, created a strong consensus to empower Congress to secure the public credit of the United States by levying its own taxes and limiting, so hardly eliminating, the financial powers of the states. Under the Articles of Confederation, both the Continental Congress and the states had the authority to coin money, but only Congress could fix a law on the value. The evident intention is to give that power exclusively to Congress under Article 1, Section 8, Clause 5. Section 10, Clause 1 contains a general prohibition against states in emitting letters of credit unless it came to be understood they were drawn on some specific funds set aside for that purpose. The result reads like a compromise designed to prevent the open-ended use of state credit without shutting down the capacity of the state to borrow at all. These provisions, together with the requirement that only goods or services could be used for legal tender, stem from the desire to insulate other states in the Union from the fiscal shocks created by any single state. A fourth category coordinates the respective powers of the states in domestic and foreign affairs. There is an evident tension between the absolute prohibition on any treaty, alliance, or confederation found in Clause 1 and the apparent authorization to enter into any agreement or compact with a state or foreign power so long as Congress consented. Finally, it is worth noting that the Union was considered sufficiently fragile that Section 10, Clause 3 allows for the state to engage in war, waiving the requirement of congressional consent in cases of imminent danger. Indeed, this military ensues loomed large in the founding period because Article 1, Section 8, Clause 15 and 16, and Article 2, Section 2, Clause 1 also contain detailed provisions for the maintenance of state militia and the circumstances under which they could also be called into the service of the United States. Lastly, the guarantee clause of Article 4, Section 4 deals primarily with the threat of invasion for which either congressional or presidential intervention is then contemplated. The mechanics of all these provisions are exceedingly complex and are set out in the Constitution. The single provision of Article 1, Section 10 that has brought forth the greatest amount of litigation is the Contracts Clause, which categorically declares no state shall pass any law impairing the obligation contract. Like the other limitations on the financial powers of the states, this clause reflects the fears of the property classes who feared the adoption of the Constitution that the state legislatures might well enact law adversely affecting the just rights of creditors. After 1810, the expansive definition of the Contract Clause revealed how broadly the Supreme Court, under Chief Justice John Marshall, viewed the danger for intrusive state legislation. So from as early as Fletcher versus Peck, 1810, and Dartmouth College versus Woodward, 1819, the clause was held to apply not only to private agreements, but also to state charters that could not be revoked except upon payment of just compensation to proprietors. It was also understood that the contract clause was not limited to debtor-creditor relationships but applied to all contracts, notably including the charters of incorporation granted by legislatures. In addition, the contract clause was read to afford protection to both sides of the agreement, buyer and seller, creditor and debtor, grantor and grantee. The Supreme Court also held in Sturgis versus Crowninshield, 1819, that the contract clause protected rights under contracts previously formed. It by a 4-3 vote, with Chief Justice Marshall and Justice Story dissenting, the court held in Ogden versus Saunders, 1827, that the contract clause did not protect from legislative invalidity any contracts made after a particular statute was enacted. The early cases also recognized the place power exception of uncertain scope for cases dealing with the public safety, health, general welfare, and morals. Finally, there was additional uncertainty as to whether the contract clause, like the takings clause of the Fifth Amendment, provided protection against state judicial as well as legislative actions. The adoption of the 14th Amendment, which imposed many direct limitations on state power, subject to both judicial and congressional enforcement, meant that the contract clause was no longer the only avenue to impose new limitations on the exercise of state power. Nonetheless, in this context, the clause's relative specificity has led to extensive litigation over the question of whether its systematic application, like that of due process equal protection clauses, continue to impose meaningful restrictions on major programs from mortgage moratorium to pension plan solvency, from bankruptcy reform to government lending practices. The larger debate today raises in its most general forms the question of whether rational basis review or higher scrutiny should be applied to claim brought under the contract clause, both as to the scope of the basic coverage and the size of power of the exceptions. This debate is about one of the many facets of the choice between the classical liberal and progressive views of constitutionalism, which pivoted sharply towards a progressive view during the 1930s, or for the most part, it remains today. Matter of debate, the first perspective, Article 1, Section 10, the classical liberal and progressive views contrasted, by Richard A. Epstein. It's commonly said that John Locke, the champion for social contract theory and natural rights, was one of the intellectual godfathers of the American Constitution. And for Locke and other social contract theorists, the major challenge was to figure out how ordinary individuals could form a state that allowed them to escape the uncertainties of living in the state of nature. The influence of natural rights theory is evident in many state constitutions, like the Massachusetts Constitution of 1780, whose explicit purpose is to form a stable order to protect the natural rights of its members. See Preamble, Massachusetts Constitution of 1780. The formation of a natural government is not intended primarily to secure safe passage out of the state of nature, a task which should already have been successfully done by the states. Rather, it was put into place a complex agreement among states that equitably distributes powers among co-equal sovereigns. That second inquiry has little to do with the preservation of natural rights as such. The difficulty of undertaking this is reflected in the structure for Article 1, which begins by defining the legislative power and concludes in Section 10 by listing the prohibitions of activity that can be undertaken only by the states. The confusion, however, only depends because some of the most important provisions of Article 1, Section 10 may address individual rights if it were understood, and Professor Rokoff notes, as federal checks on what the sovereign states are allowed to do to their citizens. In some of these cases, as with the adoption of ex post facto laws and bills of attainder, the concern is not with reserving to the national government a certain task by denying them to the states. Article 1, Section 9, Clause 3 prohibits the Congress from passing either bills of attainder or ex post facto laws in the same fashion that Article 1, Section 10, Clause 1 does for the states. The identical nature of the two prohibitions had nothing to do with the distribution of powers between levels of government and everything to do with the conviction that singling out certain people for special treatment or imposing criminal punishments retroactively for actions that were legal when undertaken were much like a natural law protection capable of universal application. Indeed, much of the debate and the Constitutional Convention was not about the propriety of these prohibitions, but about whether they are needed at all, given that the prohibited activities were universally condemned as adheres in the natural law tradition. See Daniel Choi, ex post facto, in the Heritage Guide to the Constitution. One happy circumstance is that, for the most part, these two clauses have not played a central role in constitutional litigation. The same cannot be said of the contract clause, which reads in part like a jurisdictional limitation, in part like a protection of the natural rights to contract. The clause itself was adopted from the earlier provision in the Northwest Ordinance of 1787, which provided it's understood and declared that no law ought ever to be made or have force in the said territory that shall in any manner whatever interfere with or effect private contracts or engagements, bona fide and without fraud previously formed. One interpretive challenge asks which elements mentioned in the Northwest Ordinance carry over to the slimmed-down contract clause, evidently written in more categorical terms. Part of the difficulty stems from the confusion over which or why the framers included this clause in the Constitution in the first place. One common explanation offered by Professor Michael McConnell is that it was intended to protect interstate contract from assaults by state governments. So Michael W. McConnell, Contract Rights and Property Rights, a case study in the relationship between individual liberties and constitutional structure. While true, it does not explain why the clause applied to all local contracts as well. The second explanation, which McConnell also discussed, is directed towards local abuses such as debtors' relief laws. Thus, in speaking about Article 1, Section 10 in the Federalist Number 44, James Madison denounced states' sudden changes, legislative interferences in the business affairs of their citizens, even for transactions that take place wholly within one state. The Northwest Ordinance in 1787 also raised more specific interpretive difficulties. The ordinance only protected those contracts in place before the law went into effect, which was adopted for the contract clause in Ogden versus Saunders, 1827, or the dissents of both Justices Marshall and Story. The issue bristles with difficulties. One powerful objection to the Marshall-Story position is that it flies in the face of hundreds of years of legal history by refusing to give credit to statutes of limitation, recordation statutes, and the statute of fraud, all of which necessarily impair certain contracts that lack the requisite formalities in order to increase the security of exchange overall. But it hardly follows that the prospective reading of the contract clause has to be rejected in order to accommodate these common sense cases. In this regard, it's instructive to compare the contract clause with the takings clause, where the latter allow for the taking of property for public use on payment of a just compensation. Why not therefore read a just compensation exception into the contract clause? That position is not as far-fetched as it sounds. In West River Bridge Corporation v. Dix, 1848, the question was whether the United States could condemn bridge that has been authorized by government charter. Earlier, it held that the contract clause applied to government charters in Dartmouth College versus Woodward, 1819, in which New Hampshire simply sought to take over Dartmouth College, causing harm that it could not be easily cured by paying compensation. In Dix, it would have been absurd to see that no state could ever condemn any property for public use on payment of just compensation whenever that property has been acquired by contract either from the state or from some private party. Had the court read in a just compensation exception that brought the contract clause closer to the taking clause, again by a process textual implication. In the early work, I articulated an intermediate position that first gives the contract clause prospect effect, but then allows for statutes that made a general just compensation test. See Richard A. Epstein towards revitalization of the contract clause. This additional security transaction from the statutes of limitation and the like improve the lot of all individuals governed by them, so that they do not selectively apply to benefit one group of individuals, see debtors, at the expense of others, say creditors. The same position can also apply to efforts to limit the remedies given for breach of existing contracts, as in United States Trust Corporation of New York versus New Jersey, 1977. In that case, the court refused to let states limit bond covenant in loan agreements intended to prevent the diversion of cash to other purposes without also offering some substitute protection to the lenders. Adopting this approach for both prospective and retroactive changes of contract terms allow for the consistent application of the contract clause to all contracts. This thus meets a major concern for both Marshall and Story, that a general law banning all future contracts would, under the majority opinion, escape any possibility of invalidation. It's also clear that the just compensation exception is not the only one that has to be read into the contract clause for it to make sense. Some contracts are formed by fraud or duress, and surely those common law defenses to their enforcement are not upset by its constitutional requirements. And the word list, that a simple observation means that some version of the police power must be read into the Constitution to cover these eventualities. It was generally addressed in Brown versus Maryland 1827. We deal with the Import-Export Clause in Article 1, Section 10, Clause 2, and recognize that the police power covered at the word list the removal for gunpowder. Brown gives rise in turn to the interpreted challenge of Holt in identify war forms regulations while the literal application of the contract clause beyond the obvious cases of gunpowder and other potential nuances. It is on this issue that the difference between the classical liberal and the progressive view is most vivid. The key case for these purposes is a home building and the long assessed versus Blaisdell 1934, which held that emergency legislation that allows for the postponement of interest payments on the mortgage was not impairment of contract because of the dodging rationale that merely modifying the remedy does not necessarily impair the obligation contract, even if the creditor is left worse off in consequence. At this point, the just compensation requirement is effectively limited in many cases for pre-existing contracts. The upshot is that it leads to the adoption of a general rational basis test in contract cases, similar to that which the Supreme Court adopted with respect to other forms of retroactive legislation in connection with the Due Process Clause, the Fifth Amendment in Pension Benefit Guarantee Corporation versus R.A. Gray and Corporation 1984, and the Taking Clause of the same amendment in Corley versus Pension Benefit Guarantee Corporation 1986, and they apply to the federal government. The importance of the shift in connection with both contracts and takings clause cannot be overestimated given the huge shift in power from private parties to the national government. For those like myself who believe in the classical liberal constitution, this constitutional transformation energized huge political functions that, as Madison saw, work against the interests of the public as a whole. In contrast, progressive thinkers tolerated the increased level of government activity, as Justice Thurgood Marshall wrote in Usury versus Turner Elkhorn Mining Corporation 1976. Virtually all legislative acts adjusting burdens, benefits, economic life, except to a narrow exception for laws found arbitrary and irrational, fall within Congress's authority. By implication, the same level of deference was afforded to state legislatures at this point. There is a little distinctive left to the contract clause, which is wisely swallowed up by the general presumption in favor for all economic regulations. Next perspective, further comments on Article 1, Section 10 by Jack Rokoff. The various clauses in this section cover a wide array of issues, and these clauses do leave some questions open as to just how rigorous are the limitations being imposed on the authority of the states. Yet there are the sense in which the section as a whole retains a unifying theme. The existence of this limitation demonstrates that the individual states no longer possess anything resembling the traditional conception of sovereignty. that the famous word never appearing in the text of the Constitution, also it hadn't been part of the Articles of Confederation. In designing a federal system, however, the framers of the Constitution were effectively asserting that states no longer possess a full array of sovereign powers. There were emergency conditions when the states could use modicum to military force if the militia were in good shape. But for all practical purposes, the Constitution denied states the ability to make war and conduct diplomacy with the foreign nations, both traditional markers of the sovereignty of a modern nation-state. The restrictions on the internal legislative powers of states, as for example in laws relating to the obligation of contracts, similarly derogated from any claim to sovereignty. Of course, states retained enormous legislative powers that it would continue to dominate the business of American governance for decades to come, but the idea that the state remained sovereign entities in the traditional meaning of the term no longer made any sense. The denomination of the sovereignty of the states was a topic that the framers of the Constitution had considered in 1787, and James Madison's insistence the Virginia Plan included a clause authorizing the national legislature to negative or veto state laws contravening the Articles of Union. Madison personally believed that this power should be applied in all cases whatsoever, so that the national government could not only defend itself against the legislative interference of the states, but also intervene within the states to protect minorities against unjust legislation. In the end, to Madison's deep disappointment, the convention rejected the negative, but Article 1, Section 10, the supremacy clause for Article 6, partly, but only partly, fulfilled Madison's purpose. It would take the adoption of the 14th Amendment in 1868 and the eventual development of the incorporation doctrine to give the national government the authority that Madison wanted for it all along. None of these texts uses the word sovereignty, and a major category of political thinking, and it evidently disappeared from American constitutional practice. By emptying the word sovereignty of its content, and the Constitution did both by omitting its use and by vitiating its application, did not prevent its political and rhetorical exploitation. Politicians like John C. Calhoun and the Southern secessionists of 1860 to 61 could always argue that the states were the original sovereign members of the Union and that their sovereignty could never wholly disappear. Or one could assert that the residual sovereign authority of the states while the Union was safely functioning remained a puzzle. But when the Union began to encounter fundamental challenges into its continuance, and it did with the enactment of the Alien and the Sedition Acts of 1798, for the Hartford Convention of 1815, or the nullification crisis of 1832-34, and finally during this secession crisis of 1860-61, the language of state sovereignty became more attractive. It could never describe how the Union was working, but it could become a formula for its collapse.